Good morning, everyone. My name's Helen McIntosh, and I'm the president of the South East London Chamber of Commerce. We're delighted this morning to be holding one of our regular webinars with Thackray Williams. And today we are going to have an update on employment law 2022 from Sarah Wilkinson. But before we start, as everyone knows, this is being recorded. And I'm going to ask that we will have questions at the end. And when we get to the questions, can I ask everyone to use, I'm sure you know where to find it, the little yellow electronic hand. And Sarah will answer the questions at the end. So over to you, Sarah.
Thank you very much, Helen. Thank you for having me. Good morning, everybody. I was saying to Helen just before we started that I'm much more comfortable standing in a room full of people and being able to have more of a discussion as we go. So I'm disappointed not to see more of your faces. So if you do want to turn on your camera, it would be great to see you smiling back at me so I don't just feel like I'm talking to myself. I have somehow managed to secure myself the boardroom here at Thackray Williams. So it is me at the head of a very, very empty table. So we are here this morning, thank you for joining, to have an employment law update. So sorry about the unimaginative title, but well done for signing up. It gives me the opportunity to talk to you about recent developments in employment law and also what we might expect to see in the coming months, if not years. So my first slide just covers what we're going to be covering this morning. Hopefully you should be able to see the slide. Can you see them, Helen?
Yes, I can.
Fab. So what we're going to cover, I'll go through some of the key cases from 2021, which I've just picked out a few, which I think are probably going to be relevant for a lot of you and of interest to you. And after I go through the 2021 cases that we now need to be keeping in mind for any future decisions we make about employment issues in the workplace, I will then be going on to look at the changes that have taken place this month. April is a key month for changes in employment law, so I will just talk you through the changes that have occurred this month and make sure that you are aware of those. I'll then be going on to look at the forthcoming changes that we might expect to see in employment law. There's a huge number of consultations having taken place, currently taking place, or on the horizon. And many of those are for new proposed legislation, which we are expecting to see in the long-awaited and highly anticipated employment bill. It was first mentioned in the Queen's speech in 2019, and the government have been a little busy since then with various matters, COVID, Brexit, etc. But I'm hoping that we're going to be getting that coming in the coming months, and certainly by this point next year. And then no presentation, unfortunately, is complete without a brief look at how COVID-19 is continuing to affect us 2 years on. We now are lucky enough to have a plethora of COVID-19 case law, albeit that it's only employment tribunal stage, so not yet binding on other tribunals. But we do have an idea now of how the tribunals are deciding on these new matters and very, very new scenarios that have occurred suddenly occurring in the workplace. And then finally, just a brief look at the post-pandemic working world, if we can call it post-pandemic. Maybe it should be current pandemic working world, but I think that we are all now getting to a point where we're adapting and have got ourselves sorted and worked out how hybrid working is working for us all, if that's what we're doing, 100% home working or 100% office based. So it would be interesting to hear from you what you're all doing and how it's working for you. Okay, so let's move on without further ado to look at some of the key cases from 2021. On my next slide, please, Theo. Thank you. So here, I mean, none of these cases are related at all. I have just picked out a few cases that I think are going to be of relevance that I thought I'd bring to your attention. So the first case on this slide is the long-awaited Supreme Court judgment in the case of Royal Mencap Society and Tomlinson Blake. So it's the Supreme Court, no further right of appeal, which I think many employers are very pleased about. This is now the final decision. It was handed down in March 2021. And in this case, the Supreme Court held that individuals carrying out sleep-in shifts are not entitled to receive the national minimum wage for time spent asleep. It might make absolute sense to some of you, but there were many workers who claimed that whilst they were asleep at or near the workplace, they ought to be receiving national minimum wage. But the Supreme Court has now firmly decided that these workers are only entitled to receive the national minimum wage when they are awake for the purposes of working. And now that does not mean staying awake as long as possible to make sure that you're getting pay. It means awake for the purposes of working. So this was a particularly key decision for the charity and the care sector, which faced a real significant liability for historic back pay if the outcome had been different here. So a big cheer from the charity and care sector on receiving this final judgment, which took a long time to get there. And then moving on to the second case that I've got on that slide, LA UK Limited and Geelan. This was an employment appeal tribunal decision, emphasising the importance of anti-harassment and diversity training being up to date and fit for purpose. Now, I'm sure that we have drilled into enough of you enough times that you ought to be having equal opportunities policies in places, anti-harassment policies, bullying and harassment, anything like that in place, and have given your employees training on these. But this case was a real reminder for employers that they can't just have stale policies and diversity training. That's not enough to be able to defend a claim for harassment that might have been brought by an employee. In this case of LA UK Limited and Geelan, it was an employee who had been subjected to racist comments by a colleague in the workplace. You may or may not know that employers are normally responsible for any discriminatory or harassing acts that are committed by their employees, but there is a defence under the Equality Act for employers who would otherwise be responsible if they can show that it took all reasonable steps to prevent that employee from doing the discriminatory act. So what is all reasonable steps? Usually I would be advising my employer clients to make sure that they have those policies in place and have brought them to their employees' attention, and for that to be sufficient to say that they have taken steps to prevent any harassment in the workplace. But this case was a clear reminder and highlighted that having a policy and putting training in place is simply not enough. The policies need to be regularly reviewed, and refresher training should be provided as needed as well. So just a brief reminder there that to carry out regular reviews of the policies that you do have, and to make sure that employees that have been with you for some time have taken refresher training on those policies as required. Moving on to the third case on this slide, this is the case of Rooney and Leicester City Council. And it covers quite a prevalent subject that is in the headlines a lot at the moment, which is that of menopause symptoms, and whether menopause symptoms can amount to a disability for the purposes of the Equality Act. And in this case of Rooney and Leicester City Council, again, it was an employment appeal tribunal case, which confirmed that menopause symptoms can amount to a disability for the purposes of the Equality Act. Now, that's not to say that they will always, so it will always be very fact specific, but this was the first binding decision on this issue, so it's of quite great importance. And in it, the Employment Appeal Tribunal held that it was wrong for the original Employment Tribunal to find that an employee who had been suffering from significant menopausal symptoms was not disabled under the Equality Act. Just thinking about what that definition is for a disability. I'm sure you'll know it by now, but a physical or mental impairment that has a significant and long-term effect on a person's ability to carry out day-to-day activities. So breaking that down, we've got long-term, having a long-term effect. Long-term means likely to last 12 months or more. And that's going to be one of the significant issues as to whether or not these menopause symptoms can amount to a disability. Obviously, us ladies all deal with it in a different way and have very different symptoms. So it's not going to be one size fits all. Menopause itself is not specially mentioned in the Equality Act, but this case does show that there's no reason in principle why these symptoms can't have the relevant disabling effect on any individual to afford them that protection under the Act in relation to any potential discrimination in the workplace. And so with a growing focus on menopause in the workplace, this case highlights those employers should take heed of and address any symptoms that are brought to their attention. Don't just show sympathy, but make sure you do take it seriously. And then the final case that I have on this slide is the case of Gwynedd Council and Barrett and others, which I think I'm pronouncing correctly. This one was a Court of Appeal case, and it's about a redundancy consultation process. So we all know how a fair redundancy consultation process ought to work. So I don't intend on repeating the rule book to you, but this was just quite a relevant case. I think a lot of people go through redundancy situations and have done in the last couple of years especially. And this one covered whether or not the right of appeal ought to be offered to employees for redundancy consultations and terminations. This case in the Court of Appeal held that a failure to offer an appeal does not on its own automatically render a redundancy dismissal unfair. And so the court held that it would be wrong to find a dismissal unfair just for a lack of appeal if that was the only defect in an otherwise very fair process. Now, we all know that there's no ACAS code which says that you have to have a right of appeal in the same way that there is with grievance and disciplinary processes. And so it's not something which I force on my clients when they are doing redundancy consultation processes. But of course, it's probably always better to offer than not, just to ensure that there's no argument about it. But at least we now have this Court of Appeal decision to rely on, in which the Court of Appeal confirms that a tribunal would need to look at all of the factors in any process before determining whether a redundancy process is fair. Many employers will offer an appeal in a redundancy situation as a matter of course, and that is my advice, unless there's a very, very strong reason for not wanting to, because there are obviously benefits in doing so. But in some situations, there might be reasons why holding an appeal might not be recommended. And so the absence of an appeal may not be fatal, thankfully, to the Court of Appeal on this decision. Okay, so my next slide just has 3 more key decisions from 2021. There they are. The first one being the decision of Uber. I mean, how many times is Uber going to be in the news? Finally, we have now got to the Supreme Court with this one, and we now have no further, Uber now has no further right of appeal, and the Supreme Court has finally held that Uber drivers definitely have the status of workers and so therefore benefit from the employment protections afforded to workers. So Uber are now backpedaling at great speed. I actually had the pleasure of speaking to the lawyer who was representing the workers in this case. And I understand that Uber are now changing their processes and have been changing their processes throughout since the original group action brought against them, so that any decision is not binding on the whole Uber workforce across the UK or across the world even. And so, although this is a very fact-specific case and judgment, it's always a useful reminder for any businesses out arrangements, and just make sure that they have a genuine self-employed individuals working for them and not workers or even employees who would benefit from those greater protections. I'm not sure whether anyone that we have on the call today recognises a trade union, but this second case of Coastal UK and Dunkley is of interest to employers that do recognise a trade union. Again, a Supreme Court decision which held that making a direct pay offer to employees covered by collective agreement is unlawful. These direct offers can only be made, just as a reminder, once the collective bargaining process has been genuinely exhausted. So employers who recognise a trade union do need to ensure that they follow any collective bargaining framework agreed with the union before making any decisions with their workforce. And the final 2021 decision that I just wanted to draw to your attention, is quite an interesting one, is the EAT case of Forstater and CGD Europe. So this is that gender critical beliefs are capable of being beef. So we obviously have the protected characteristics, the 9 protected characteristics in the Equality Act, which afford people discrimination protections. And often there are quite unusual beliefs that are put forward as in this case was the view that sex is fixed and should not be conflated with gender identity. So the case was concerned only with this very narrow legal issue of the scope of philosophical belief and whether or not the claimant in the case would be able to rely on philosophical belief as a protected characteristic. But it's certainly of interest for highlighting that some beliefs may be capable of protection, even if they are. 2021 key case update, the cases that I thought might be of interest to you, based in 2022. So April is the month that it all happens in the employment sphere. It was actually 2 years ago now that we had quite fundamental changes to what we might expect to see in contracts of employment, which were brought about by the April changes. I'm still with all of the relevant contractual provisions that are required by the Employment Rights Act. We now have the need to include anything to do with training offered to employees, all paid leave that is offered to them, any benefits that are offered, and this were all stuff that wasn't necessarily required in the employment contract pre-April 2020. But you will be forgiven, or perhaps not, given everything else that was happening in April 2020. And the sudden need to make sure that you were able to get your workforce working from home immediately on Boris's announcement. But it is now 2 years later, so perhaps the leeway in letting that slide is a little less. You will need to make sure that your contracts include those provisions. So if you have any concerns whatsoever, or just wanted somebody to look over your contract and make sure that it does include everything that it needs to, then we do offer a free 2-hour HR health check at Thackray Williams, which will allow a free review of your contracts just to see whether there's anything that did need to be changed in those. So do get in touch if you wanted us to look at your contracts under that health check. So that was 2 years ago. You don't want to hear about that. You want to hear about what's happening now. So you can see here on this slide, the first change was on the 1st of April. I don't know who wrote the rule book. We've got changes on the 1st, changes on the 3rd, and changes on the 6th. But here we are. The first change in April 2022 was the increase to national minimum wage. I've set these out on the slide here with the current, or I should say old rather than current, the old rate and the new rate, and then the percentage increase, which you can see in some cases goes above 10% increase in that national minimum wage. So very different to what you might expect to a normal 1% pay rise. And increasing payroll costs is likely to be quite a key issue for many employers in the coming year. It was December 2021, wasn't it, when inflation reached its 30-year high? And so employers, I think now, in light of that inflation figure, are likely to find themselves under quite a great deal more pressure to increase their wages. On top of this, we've seen this additional cost pressures with the national minimum wage increase on the slide here. And so I've been advising my clients to make sure that they are looking at their existing pay structures as early in the year as possible, given these increases which have come into effect this month. They are significant increases. It's more significant than they usually are. And increasing pay at the bottom end of the pay scale like this is likely to lead to quite a knock-on effect to increasing pay levels above the national minimum wage. So I would advise you, if you haven't done so already, to check your pay rates against these new rates and ensure where necessary that you do increase remuneration as required. The Great Resignation is not a myth, unfortunately. So many of my clients have found their workforce moving on. It was actually only a couple of weeks ago that I had a discussion with somebody who was moving into their 4th role in 2 years. not because he was unhappy where he had moved to, but because he was able to give himself such a boost in salary just by moving on, moving on and moving on. It's really an employee's market at the moment. And unfortunately, they are the ones demanding this increase in pay, with everything else around us increasing as well. My next slide covers the changes that have taken effect in relation to family-related pay on the 3rd of April and to statutory. Looking first at family-related pay, statutory maternity, adoption, paternity is currently at £156.66 per week, which is just over a 3% increase on last year. And then the statutory sick pay on the 6th of April went up to £99.35 per week, just over. And again, be up to you and to HR and employers to make sure that any of their staff on family-related leave or on sick leave are paid these statutory minimum rates. And I would also suggest that you review any policies and documents that might mention these rates. Excuse me. So I wouldn't usually, when drafting these policies, refer to the rates, and these will need to be updated. And again, these increases, in the same way as I mentioned with national, on employers who offer enhanced company sick pay or enhanced family-friendly schemes, to see whether what they are offering is actually in the market for what they might expect to be offering other employers equivalent to them are offering. Goes on my next slide, which is that for the figure for weekly pay. If we could just move on, please, Theo. Are we there, Theo? Thank you very much. Hopefully I have, oh, hang on, we've gone on too many. Maybe your computer froze or something. Sorry, I should have mentioned that I should thank Theo in advance for being my glamorous assistant. Right, so here we are. The final change on the 6th of April was the weekly pay increase, and that was from £544 per week to £571 per week. Now that is the cap on a weekly pay that is applicable to when you might be calculating a statutory redundancy payment. Statutory redundancy payments, you will know, are based on a statutory formula based on a weekly pay capped at the figure in the second bullet point there, length of service capped at 20 years, and an employee's age. I'm sure that when working out statutory redundancy payment, most of you make use of the government online calculator, which is fantastic just for being able to input all the figures and getting the figure, the correct figure. But if you do it by hand yourself, you will see now that the maximum statutory redundancy pay that is payable for employees who are at the cap of the weekly pay, the cap of the length of service, and of nearing retirement age, I shouldn't say that, slightly older in the in terms of years, is now £17,130. So that's the maximum that you might expect to be paying out as a statutory redundancy pay. So just ensure there that any calculations that you do carry out are using that new weekly pay figure, because that's now been in effect for a few weeks now. Okay, oh, I said that was my last change, but it wasn't. It was my last change in terms of figures. But here, this one is affecting all of us, isn't it? It's the new health and social care levy that came into effect on the 6th of April. So this social care levy has been introduced to help fund health and social care. Thank you, I think you've got it there. And so this was introduced UK-wide from the 6th of April to help fund health and social care. It is being collected via a 1.25% increase in national insurance rates for employers, employees, and the self-employed. This means that it won't affect anyone who earns under the NIC threshold, which is currently set at £9,568, and it also won't affect in this year those above state pension age that do not pay national insurance. However, from 2023, it's expected, although not yet confirmed, that this levy will be collected as a separate levy, separate from national insurance, at a rate of 1.25%. So those people who missed out this year, who are above state pension age and not affected by the NI increase, will be affected from April 2023 with the introduction of the levy, if that does take place as expected. Right, and then my next slide. If you've been living under a rock, you won't know about the extra bank holiday we get this year for the Queen's Jubilee. This is just a reminder here that there's going to be this additional bank holiday. The usual late May bank holiday has been moved to Thursday the 2nd of June, with the Queen's Jubilee being on Friday the 3rd of June, giving us another 4-day weekend to look forward to without the benefit of our holiday. Now, whether or not employees are actually entitled to take off, and depending on how mean you're feeling, will depend on the wording of their employment contracts. So there's various different typical wording that you might expect to see in employment contract holiday clauses, which state that an employee is entitled to a set number of days annual leave, which is inclusive of the 8 usual bank holidays, or it might say that they're entitled to annual leave plus the usual bank holidays. So that those wouldn't necessarily allow them to take off this extra day, but I doubt many of you are feeling that mean. So on a practical level, I would just remind employers to be mindful of how you might manage a possible influx of holiday requests for the week commencing the 30th of May. This will be a much shorter week. It will only be a 3-day week, and I think that means that full-time employees will be able to benefit from 9 days off work without only using 3 days annual leave. So just make sure that you've got appropriate cover in place as required there. Right then, so now I want to move on to the eagerly anticipated, I say eagerly anticipated, but us employment lawyers are really looking forward to getting our teeth into something new, employment bill that was first mentioned in the Queen's speech in December 2019. In this, it was announced that the government is planning this new employment bill, which would apply in the main to England, Wales and Scotland, and would cover, amongst other things, the items referred to here on this slide. So a single enforcement body, it's been proposed that this single labour market enforcement agency is put in place to better ensure that vulnerable workers are aware of and can exercise their rights, and which will also help to support business compliance with employment laws and legislations. The next bullet on that slide talks about tips going to workers in full, and we have had a plethora of consultations on tips and service charge and how that ought to be given to workers. The suggestion is that there will be legislation put in place requiring employers to pass all tips and service charges to workers, and that this will be supported by a statutory code of practice to ensure that the tips are distributed on a fair and transparent basis. So one to watch out for if you have employees working who receive tips and service charges. We've also got there the right to request a more predictable contract, and I'm going to be coming on to this in more detail. The extension of redundancy protection for pregnant employees and maternity leave returners. We've got leave for neonatal care, carers leave, and also making flexible working the default. So quite a few things to be looking forward to there. On the 23rd of March last year, the government confirmed that the bill would not be introduced in that parliamentary session, but would only be introduced when parliamentary time allows. I think they can probably be forgiven that they've had a fair amount on their plate for the last couple of years. But then we were a little surprised that the Queen's speech delivered in May 2021 made no mention of the employment bill whatsoever. However, it was reported after that the bill would be introduced when the time is right. So is the time right yet? On the 1st of April earlier this month, it's been reported that a government official has indicated it will likely be excluded from the Queen's speech next month. And so I am not sure when the time is right, but we do know that the consultations for all of the proposed legislation are underway or already completed. And so hopefully by the time we get around to looking at the nitty-gritty, all those consultations ought to have taken place and we'll be ready to go with it. So I'm going to go through some of the proposals with you just so that you're aware of what's likely to be coming up in the coming months, if not years. My next slide talks about the flexible working proposals. If we can move on to that one, lovely, thank you. So a consultation on flexible working closed in December 2021. It sought proposals on or responses to proposals on extending the existing right that already exists for the right to request flexible working. And it's anticipated that the changes could include a new right to request flexible working from day one. So currently the right is not available until 26 weeks continuous employment. Despite the name of the consultation, which was Making Flexible Working the Default, I think that was the name of it. Despite that name, it has been made reasonably clear that there is no intention whatsoever to introduce a right to work flexibly as a default. So I don't know who came up with the title, but instead the changes are there to modify the current right to request flexible working. So those of you that are already au fait with the current legislation, it's not got much teeth. It gives employees the right to request, but it sets out 8 grounds for refusal. And if you don't want to agree to that request, generally you can get your refusal within one of those 8 grounds, and then there's no further recourse at that point for employees having made the request. It doesn't sound like much is going to change other than for the right to request to be made from day one. But you can see that the 5 proposals set out in the consultation are there on the slide. Making the right to request flexible working a day one right, whether or not the 8 business reasons for refusing a request all remain valid. So it might be interesting to see whether or not we don't have so many options available to us to refuse that request. Requiring the employer to suggest alternatives, that might be an option that is put forward in the new proposed legislation. So rather than just saying no, coming up with some proposed alternatives. The administrative process underpinning the right to request flexible working is likely to change, and also the possibility to request a temporary arrangement rather than something more permanent. There is also a proposal in there to require employers to state in job adverts whether or not a job is open to flexible working, and that's also likely to form part of the new employment bill. So it remains to be seen how many of these proposals are going to form part of whatever new laws do come about and when those might arrive. But it's useful to know that that is on the horizon. I actually have seen in quite a few job adverts at the moment that are out there that employers are making it quite clear from the outset that a job that part-time and full-time are being considered. Hybrid working is being considered, home working and office working. So it sounds to me as though employers are, rather than waiting for this to be even put in as law, making that a standard now anyway. And we've shown great flexibility, haven't we, in the last couple of years? So I think with that, the legislation is really behind how we're actually already working in practice. Okay, so the next one I wanted to just draw to your attention from the employment bill is that of carers leave. So a new type of leave, which in September 2021, the government published its response to the 2020 consultation it had in place on carers leave. In this, it's confirmed that it plans to legislate an entitlement to carers leave for employees as a day one right. So it's anticipated that under these proposals, employees will be able to take up to 5 days unpaid carers leave each year. They could take that flexibly from half a day at a time to a whole week at a time to carry out their caring responsibilities. And the idea is that it's for planned care or making arrangements for planned care, so it's not meant to be used for emergencies, and it's separate from the right to take time off for dependents. Employees will be required to give notice that is at least twice the length of the time being requested, but there is a strict refusal ground for employers if, for example, the business is likely to be unduly disrupted by the carers leave, carers leave being allowed. The person being cared for must have a long-term care need, but it's not anticipated that there will be any evidential requirements needed for that. But again, further details are awaited, so watch this space on that one. As with any of these things, of course, we'll be needing to update policies, update handbooks, etc., just to ensure that we've got everything, all of our employees' entitlements in one place there. Okay, and onto the next slide, I mentioned in my summary of the employment bill that we have this new right for workers with variable hours to request a more stable and predictable contract after 26 weeks service. So it's expected that the employment bill will introduce this right for workers and for them to also have the right to receive reasonable notice of what their working hours are when they are working variable hours. They will also potentially get the right to be compensated where their shifts are cancelled without reasonable notice. Now, this follows the EU Transparent and Predictable Working Conditions Directive, which is due to introduce very similar rights on an EU-wide basis in August this year. And so we all thought that Brexit was a fantastic idea, but it looks like we are following suit anyway. Sorry about that siren going past my window. I almost called it a DDAR, as I would call it to my 2-year-old son. Anyway, again, as with all of these employment bill proposals, the further detail on how it's going to work in practice are awaited. But just so that you're aware, we are likely to be seeing tougher laws in this area in the coming year. So that's one to watch out for as well. No employment presentation is complete in my mind without some word on sexual harassment. It makes my area of law the sexy area of law. Who snogged who in which stationery cupboard? So we've got another proposal in here. On the 21st of July 2021, we had the response to the consultation on workplace sexual harassment that has been launched all the way back in 2019 now to determine how to deal with sexual harassment in the workplace. And the government's proposed changes are intended to encourage employers to prioritise the prevention of sexual harassment by taking more proactive steps to make the workplace safer for everybody. It will also require employers to place more emphasis on the active prevention of sexual harassment in the workplace. So it's not just going to be a case of having that policy in place, as I mentioned in my previous summary of key 2021 decisions. But just to summarise some of the key changes that are anticipated about third-party harassment, the government will be introducing a new duty for employers to prevent sexual harassment in the workplace. They'll also be introducing a new duty for employers to prevent third-party harassment, that is by a client or a customer or supplier that might visit the workplace. All of this will be introduced when parliamentary time allows, with no commitment for a specific implementation date. So don't get too excited just yet, but it's just so you're aware of what is on the horizon. Interestingly, the government have also said it will be looking closely at extending the time limit for claims brought under the Equality Act. So just to make our life a bit harder, at the moment we're very aware that everything has this 3-month time limit, but that extension, there might be an extension to Equality Act claims of 6 months to be able to bring those claims, keeping in mind the current pressures that the Employment Tribunal are currently still facing. So that will be interesting to see whether or not that comes into place. And then finally, the Equality and Human Rights Commission is going to be asked by the government to produce a statutory code of practice on sexual harassment in the workplace. The government will also publish separate practical guidance for employers to complement that code. It remains to be seen whether or not there's going to be an uplift of up to 25% for failure to comply with it, in the same way that there is for failure to comply with the ACAS Code of Practice on grievance and disciplinary procedures. But of course, there is likely to be greater compliance by employers if there is this additional financial penalty. So I'm all for it. But we'll have to see whether or not that is implemented as part of the proposed legislation. Theo, you already went on to my baby slide. There we go. So we have got this new pledge to introduce a right to paid neonatal leave, and that's to a right to 12 weeks paid neonatal leave for parents whose babies spend time in neonatal care units. Although there's no set date as to when this will be introduced, as with everything else that I have just been talking to you about, it is expected that this will form part of the employment bill when it does come into being. And it's anticipated that the leave will be a day one right from day one of employment. The definitions of parent and neonatal care are still yet to be confirmed, as are the notification requirements. So there's not much more I can tell you about it, just that it is on the horizon. And then we have also got a commitment to improve redundancy protection for pregnant employees and maternity returners. You might be aware already that there is this protection in place for people who are currently on maternity leave, giving them priority for alternative employment opportunities if a redundancy situation arises whilst they're on maternity leave. So that is being proposed that is extended to people who are pregnant and have notified their employer they are pregnant, and to maternity returners. And I believe that the suggestion is for them to be protected for 6 months after coming back from maternity leave. And those proposals obviously include similar protections of returning from adoption or shared parental leave as well. Right then, so that is my my whistle-stop tour of the employment bill and what to expect on in the coming months, or if not years, if we don't hear anything about it next month in the Queen's speech. But moving on, just to give you a little look at what COVID-19 case law has been decided by an employment tribunal. So if we could just move on to the next slide. Lovely, thank you, Theo. I don't propose to go through everything, but I've given you, I mean, there's so much now in terms of tribunal case law, but they are all, and be wary that they are all first instance decisions, which means that they're not binding on any other tribunals. Because it just hasn't had the time to go through the system yet. So when we have a binding decision, I'm no doubt that will go out on our mailing list, and I'm sure everywhere else that you're subscribed to. So if you want to keep an eye out for those, then do make sure that you're subscribed to the mailing list. So we've got, and I've put on this list a few examples of some of the ones which might be of interest to you. If you perhaps have current live claims in the tribunal system, or you're still in dispute about about some COVID-19 related employment issues. So we've got there raising concerns about safety measures at the start of the pandemic, raising concerns about lack of PPE. In both of those first two cases, the employee claimed to be automatically unfairly dismissed. I've put the names of the cases on the slides there, so that if you're interested in particular subject matter, you can hopefully do a bit of Googling and find out what the result was of these cases, because I don't think I'm going to have time to be able to go through them all. There are a huge number of furlough leave and pay disputes. I haven't put down a name there because there are so many of them, and I don't think they're going to be relevant unless you've already got a live claim going at the moment, because obviously furlough pay and furlough leave ended last year. We've got claims about dismissal for breach of government lockdown guidelines. There's also claims for dismissal for breach of the self-isolation guidelines. We've had dismissals for refusing to be vaccinated, and you can see there that was in a nursing home. And then the final two cases that I think are probably of particular interest and may well be relevant are relating to employees who have refused to attend work or have refused to return to the office after having worked from home for a period of time. Now, these are the cases of Quelch and Courtiers Support Services Limited, and the case of Moore and Ecoscape UK Limited. I thought this was probably, these two were probably going to be of the most interest to you, as everybody was forced to allow home working in March 2020 and beyond. And so I thought I'd go through the facts of these two cases in slightly more detail, as they both had a very different outcome. So starting first with Quelch and Courtiers Support Services. If I just give you a bit of a background as to what the case was about. Mr. Quelch worked for Courtiers Support Services, which provides financial services for individuals and companies. He lived at home with his girlfriend, who suffered from asthma and also had a heart condition and was classed as clinically vulnerable. So on the 18th of March, 2020 this was, Mr. Quelch discussed his concerns for his vulnerable girlfriend with his manager, and it was agreed that he could work from home. That was before the announcement that everyone must work from home. The following day, on the 19th of March, the government advised everyone to work from home where possible, with effect from the 23rd of March, unless they were critical workers. Courtiers took the view that its employees were critical workers because they worked in financial services. Although most of its employees did work from home during March and April 2020, it began to require staff to return to the office on a phased return from May 2020. Mr. Quelch was required to return on the 6th of July 2020. It was accepted by Courtiers that there were no issues with his performance whilst he had been working from home or in relation to his interactions with colleagues. Mr. Quelch repeatedly raised health and safety concerns, and he was concerned that Courtiers were not complying with the government COVID secure guidelines on home working and social distancing. He was also concerned about sharing an office with two colleagues that had school-age children, thereby increasing the number of contacts outside the home to which he was exposed. So Mr. Quelch's request to continue to work from home until government guidance on homework changed was refused. He was then advised that his only options were to take unpaid leave, annual leave or sick leave, and that he would be disciplined if he did not return. He was put on unpaid leave when he didn't return to the office, and his remote access to the IT systems was removed. He was subsequently disciplined. His request that the disciplinary hearing was held remotely was refused. Courtiers also refused to reschedule the hearing to accommodate his companion. I think you can see where this one is going. He raised a grievance that Courtiers was not complying with government COVID secure guidance on allowing employees to work from home where possible, and also about social distancing guidance in the workplace. And finally, he was summarily dismissed for gross misconduct. Now, I said I think you can see where this one was going, and you were probably right. The Employment Tribunal found that Mr. Quelch had been automatically unfairly dismissed for refusing to return to the office. And they also held that his dismissal would have been unfair under the ordinary unfair dismissal test, as Courtiers had failed to show a potentially fair reason for his dismissal. And also the sanction and the procedures it followed were completely outside the range of reasonable responses open to the employer. So the lesson to learn in this case is that normal rules of employment do apply even in the abnormal circumstances that we sometimes find ourselves in. In comparison, we have this separate case of Moore and Ecoscape UK Limited. In this case, Ms. Moore organised sales and administrative support for Ecoscape UK Limited. When the government ordered the first national lockdown, Ecoscape closed and initially looked to furlough its staff. After taking certain steps to comply with the government's workplace guidance, including hygiene measures and introducing shift work to reduce the number of people at work at any given time, Ecoscape reopened its workplace. Ms. Moore didn't feel safe returning to work, and Ecoscape suggested that Ms. Moore could have a separate office with her own equipment. They invited her to come in and look at the proposed changes to the facilities, but she was reluctant to do so and asked to continue to work from home. Ecoscape explained that this would not be possible given that the nature of her work involved dealing with deliveries and with customers. So after an unsuccessful grievance and an appeal, she resigned, claiming constructive dismissal, which she claimed was automatically unfair. In this case, and in comparison to the other, the Employment Tribunal held that the Ecoscape was not in repudiatory breach of contract. Ms. Moore was not automatically unfairly dismissed. They accepted that she had significant concerns regarding COVID, but considered that she had a general fear about being required to leave her home rather than a specific concern about her workplace safety. Now, I think this is quite a relevant one here, because so many people talk about there being this precedent put in place about home working and, well, it's all working absolutely fine and I'm not coming into the office because I couldn't possibly sit next to somebody. But in this case, Ecoscape had done everything it could to ensure workplace safety. So really it was Ms. Moore's general fear of actually leaving home rather than coming to work. The court held that Ecoscape had taken all reasonable steps to accommodate her concerns. They had reacted patiently, allowing her time to regain her confidence and to engage with her on a regular basis. And they held that she could have averted potential risks by following the general hygiene guidance provided to members of the public and by adopting the measures that Ecoscape had put in place for her. So ultimately, the tribunal found that she was unwilling to explore compromises, and it remained to her home working or nothing. So it's encouraging to see in that case that the tribunal saw that the employer did do everything it could do to assist a claimant with her concerns, whilst still expecting that she continue to fulfil her role for the company. I mean, we can't just be expected to allow employees to get away with home working 100% of the time if that's not going to be feasible for their job. So if any of you have experienced or are still experiencing difficulties with employees amidst the ongoing COVID-19 outbreaks that continue to appear, then please do get in touch and we should be able to help guide you through these. And then my final slide for today, and I think that I'm doing okay on time, is just a little discussion on how post-pandemic working is working for you in the workplace and for us as employers. I was just having a little brief chat with Helen in advance of this webinar today to talk about how Thackray Williams have been putting their hybrid working policy into action, and it seems to be working very well. We're lucky enough to have lovely swanky new offices, which I don't believe hold enough desks for employees, because it is just assumed that people will now be working from home for a period of their working week. So depending on the number of days that an employee works, if they are full-time or part-time, then our hybrid working policy allows for a set number of days at home and a set number of days in the office. And there is always a requirement for every member of a team to be in on one day each week. So for example, in the employment team, we're always in on a Thursday, that's our anchor day. So we do get to still say hello and greet each other. I'm lucky enough that I'm 10 minutes down the road from my office, so coming into the workplace isn't too much of a big deal for me, and I do prefer it. But I can definitely see people's point of view to cutting that commute into London that some people have. So obviously there is still the requirement to try and manage COVID risk in the workplace. I don't know whether or not you still have social distancing rules in place. Isolation rules if somebody does get COVID, whilst there's no legal requirement now for people to remain in isolation. Certainly here we still require people to isolate if they have tested positive for COVID. We've got hand sanitizer everywhere, as I'm sure you all have, and fresh air wherever possible with windows open, etc. And then obviously we now have these home working and hybrid working and standards, and sometimes home working is for some people 100% of the time, if that's allowed. I certainly have some clients that have closed their office entirely and now allow home working 100% of the time for their employees, because that just reduces a huge overhead, doesn't it, with the office costs. But what I would say is that with home working and hybrid working, you ensure that you have updated your contracts, you have the policies in place ready and relevant for those, so that all employees can be fully aware of what's expected of them and what they can hope to achieve. Hopefully you haven't seen too much of a change with home working in place. I know Helen's currently sat in her kitchen, albeit that you can't see behind her with her wonderful banner. If I was working from home today, you'd be seeing my boys' bunk beds behind me. But we're all getting there with sorting it out, and I hopefully are there now with 2 years down the line. But policies and contracts are my big bugbear. Make sure they're up to date. Make sure your employees know what is required of them. And I think if that's probably my last slide. Theo, if you go on, it says thank you so much for listening to my voice for the last hour. I do know that these webinars can feel a little bit stale when you're listening to one voice for a whole hour. So I hope I have been informative and engaging, so that you're still awake out there. I did request a morning slot so that I didn't have the graveyard shift of a post-lunch webinar. But I think I've got a few minutes still to take some questions, if anybody does want to ask anything.
Thank you so much, Sarah.